Eku iluna, all rise. Kinohonei ka aha ho'okolokolo ho'opi'iku e o ka luna kanawai hano o Catherine G. Leonard. A me ka luna kanawai hano o Keith K. Hiraoka. A me ka luna kanawai hano o Karen T. Nakasone e ho'omalu nei. The Intermediate Court of Appeals is now in session. The Honorable Catherine G. Leonard, Keith K. Hiraoka, and Karen T. Nakasone presiding. Enoho ilalo. Please be seated. Case number CAAP-22-516, Sierra Club versus the Board of Land and Natural Resources, Alexander and Baldwin, East Maui Irrigation Company, and the County of Maui versus Sierra Club. Trisha Akagi, Melissa Goldman, and Mariana Lowy Gerstmar for the appellants, David Kimo Franco for the appellee. Argument on the merits.
Counsel, would you like to make your appearances?
David Franco with the Sierra Club. Thank you.
Please be seated. Ms. Goldman, I believe you're up first. And I understand that you are going to argue for 13 minutes and save 7 minutes for rebuttal.
I'll actually do, I'll do 16 minutes or 15 minutes and 5 for rebuttal. Thank you.
Okay, so just so you understand, then I'm gonna change my notes. So we'll give you a yellow light 2 minutes from the end of your argument and a red light when you're done. And if you go over, that'll count against your rebuttal. And that's the same for everybody else. All right, please go ahead.
Thank you, Your Honor. May it please the court, Deputy Attorney General for the Board and Goldman for the Board of Land and Natural Resources. This case is a secondary appeal from the board's denial of Sierra Club's contested case hearing petition regarding annual revocable permits for water diversion in East Maui. I'll focus on 2 key points today. First, Sierra Club was not entitled to a contested case hearing on the 2021 RPs under the well-settled 2-part test. The second point relates to our cross appeal and argues that in crafting the remedies for its erroneous decision, the circuit court exceeded the limits of its jurisdiction, of its appellate jurisdiction, impermissibly prejudged the outcome and ordered a contested case hearing in violation of the Mauna Kea case, and improperly disregarded DLNR's expertise and experience in this area, instead substituting its own judgment for that of the agency. So for these reasons, we respectfully ask this court to reverse the challenge decisions and direct the circuit court to enter judgment against Sierra Club. A few preliminary points for context. Revocable permits are temporary permits for the use of state lands under HRS 17155. And as the name implies, RPs are revocable on 30 days notice. They can last for up to a year, so usually they're renewed annually, which also allows parties like Sierra Club to participate annually, as Sierra Club has done for the past 5 years.
So, Ms. Goldman, my understanding is these revocable permits have been issued year after year after year for decades. Does that affect how we should think about them?
Respectfully, Your Honor, no. The agency believes that long-term leases would be preferable, of course, and we've made that transition for water diversion in East Maui a high priority. Staff's been working diligently, but transitioning to a sustainable long-term lease takes time, involves a lot of stakeholders.
How much time?
It's difficult to say, Your Honor. It's the final environmental impact statement was accepted and not challenged, so that's a big plus for us. But it might be another. I would be speculating. It could be another year or 2.
Okay, but there's been no long-term lease in place since 1986. Is that correct?
I
Or
believe so,
2000?
yes.
Okay.
Yes, so there's a lot of history to this case, and because so many different proceedings were going on at the same time, I'll try and situate us. First came the trial action regarding the RP renewals for 2019 and 2020, which involved nearly identical parties, and it was heard in August 2020 before the same circuit court who presided here. Second came the agency appeal, which are the proceedings underlying this action. The agency appeal came to circuit court on review of the board's decision to deny Sierra Club's contested case hearing petition on the RPs for 2021. And within just weeks of its trial decision against Sierra Club, the circuit court contradicted itself and ruled for Sierra Club in this matter. Although the ordered
Okay, wait, I do have a question on that.
Yes.
What is the authority for the argument that August, I think it's 2020 trial is sufficient to satisfy due process regarding the 2021 revocable permit?
Mhm. Well, the argument is that Sierra Club's position in the trial was substantially similar to its position that it's attempting to argue here. The parties were nearly identical. We were dealing with the same RPs, only a different calendar year, the same area of land, and virtually no updates at all from Sierra Club. There wasn't a shred of evidence presented that the impact to their interests may have changed. It was only a matter of weeks between closing arguments in the trial and the board meeting when this petition was.
Didn't the terms and conditions of the revocable permit change?
They changed very slightly, Your Honor, but not in a way that would have impacted directly the interests of Sierra Club's clients. Now, the central issue, let's see, although this ordered contested case hearing did eventually happen, and there were additional lawsuits filed, both challenging the result of the contested case hearing decision and order, and also based on the board's denial of the next contested case hearing petition they filed on the 2023 RPs. And actually, just this past week, Sierra Club again requested a contested case hearing, this time on the RPs for 2024. The central issue presented to the circuit court in the agency appeal was, did Sierra Club have a right to a contested case hearing on the 2021 RPs? Fundamental fairness and applicable statutes dictate that we limit ourselves to the record when considering that question, because we should consider only the information that was before the board at the time that it made its decision, which was November 2020. So turning to those two substantive points, I'll first focus on Sierra Club's alleged entitlement to a contested case hearing, and then I'll talk about the remedies. Pardon me.
Okay, well, while you're having a sip of water, I think one argument I want to make sure you address is Sierra Club has cited cases, including Maui Electric, saying that under Article 11, Section 9, the rights that they're trying to protect in a contested case hearing are substantive and property interests as defined by law. I'd like you to make sure you address that, please.
Absolutely, Your Honor. If it's okay with Your Honor, it might take a few moments to get there, but I will. I'd just like to lay out the test first. The test for, let's see, a contested case hearing can be required by statute or rule or constitutional due process. Here, everyone agrees constitutional due process is the applicable question. And the test for constitutional entitlement comes from Flores, and it's twofold. It asks whether the particular interest claimed qualifies as property within the meaning of the due process clause of the Constitution. And if it is, the second part asks, then what procedures were required to protect it. Now, the board disagrees that Sierra Club's asserted aesthetic and recreational interest in streams and hiking trails is sufficient to rise to the level of constitutionally protected property interest that's defined by any law relating to environmental quality as required by Article 11, Section 9.
And do you have some authority? Oh, go ahead.
Is there something in the record that indicates why the board denied the contested case request?
Well, the transcript of the Sunshine meeting itself is in the record, and I believe that the board denied the request for reasons stated on that transcript. I can get you the exact page number and docket if you'd like.
Because the minutes don't indicate the reason, do they?
I don't think so. Yes, the minutes are generally summary minutes, so they don't always go to that much detail. But we've maintained throughout these proceedings our opposition to this property interest element. But today we'd like to focus on the latter part of the Flores inquiry.
Okay, so before you
Yes.
move to step number 2, I want you to answer my question, which is there any authority that you think we should rely on the issue of the property interest? Because it does seem that they've cited cases that say there is.
Well, we strongly dispute that they do have that property interest here. And we would cite to Flores for that. The interest asserted is not specifically defined or conferred by laws relating to environmental quality. And I know my colleague for representing A and B EMI is going to address that in more detail.
Okay,
The interest asserted is not, but even if a property interest exists, no additional procedures were required to protect it. Now, Sierra Club was not entitled to an additional adversarial proceeding in order to protect any rights, even if they had proven them. The second half of the Flores test acknowledges that due process is not a fixed concept. The hallmarks of due process are notice and opportunity to be heard, but the amount of process due, if any, varies from situation to situation, kind of like a sliding scale, often depending on the nature of the property interest. To determine what specific process is due, if any, we balance 3 factors that are attributed to Sandy Beach, so we call them the Sandy Beach factors. They are the private interest to be affected, the risk of erroneous deprivation of the interest through procedures actually used, and the probable value, if any, of additional or alternative procedural safeguards. And third, the governmental interest, including the burden that additional procedural safeguards would entail. All 3 of these factors cut against Sierra Club in this case. First, Sierra Club provided no concrete evidence of 2021 RP impacts that would require new adversarial proceedings beyond its extensive participation in both the trial on the 2019 and 2020 RPs and also at the board's Sunshine meeting on the RP renewals for this action. That is, in its contested case hearing petition, which is dockets 128 and 129, Sierra Club presented no new evidence of individualized harms, instead relying on the exact same 2019 declarations that it had prepared in advance of trial.
so what requires them to have new evidence when it's a new permit?
Sure. So that authority comes from many cases, but essentially speculation about future constitutional injuries isn't enough to force legal proceedings on its own.
Why don't you just give me one?
I'm sorry?
Give me one.
Let's see, the Costal case, for example, 445 US 198, 219 through 220s, talks about that certain factual issues regarding claimed greater effects of an action that an agency says are not enough do not compel a trial type contested case hearing. Also in the Georgia Pacific case for Georgia Pacific Court v. EPA, 671 F.2D 1235, this case supports the proposition that the trial type contested case hearing procedures are not helpful, where all the petitioner argued was a hearing was needed to sharpen the issues and fully develop the facts. Sierra Club Association for the Environment v. Federal Energy Regulatory Commission, a Ninth Circuit case, 744 F.2D 661.
So were any
Also-
of those construing Hawaii contested case rights?
Well, in the Flores case, which was construing this same right, or similar rights under Hawaii law, the applicants found that applicants for a contested case hearing must show that they would, quote, put forth evidence and arguments materially different from that which has already been proffered. That's at page 127.
Right, but Flores involved a second contested case hearing. And here they're even Sierra Club's just trying to get a first one.
That's true, Your Honor. However, all the hallmarks of due process require are notice and opportunity to be heard, and we would argue that they had received that process and then some via a trial on the merits of RP conditions for 2019 and 2020. They had a full opportunity to conduct discovery, depose witnesses such as agency experts, to cross-examine witnesses at trial. And within months of that hearing, within months of the trial ending, they again are asking for something, for essentially the same thing again, without providing any reasons why.
What about the fact that they are asking for a hearing before the same judge who presided over the 2019-2020 trial, and that judge determined that they had brought forth arguments sufficient to require a contested case hearing? I mean, it was the same judge who did the whole trial.
Well, respectfully, Your Honor, that the primary decision there on whether Sierra Club was entitled to a contested case hearing was for the board to determine. The board was acting as the fact finder in that situation. The circuit court was sitting in an appellate capacity.
Okay,
Now-
so they do fact finding at sunshine meetings?
Yes, absolutely. They air all of the issues. The board has an opportunity to weigh credibility of people testifying before them. They don't allow cross-examination of agency experts, but that's well supported by law as well.
Okay, so I think you argued in your brief that the circuit court only reached the first step of the Flores test.
Yes.
And can we weigh the factors in the second step, or do we need to remand for the circuit court to do it?
Your Honor should weigh all of the factors in the test.
So we should weigh it on appeal and not remand?
Yes, Your Honors. This court should weigh it on appeal.
Is that because this is a secondary appeal and we're basically reviewing the
Yes.
decision of the board?
Yes, absolutely. Secondary appeal, we're reviewing the decision of the circuit court, but really the decision of the board is what's at issue.
All right, thank you, Ms. Goldman.
I'm sorry, Ms.
Oh, go
Goldman.
ahead.
Because she's arguing for the board, I wanted to ask a semantic question, and I suggest that it not be
Okay,
taken against your rebuttal. We're actually only dealing with 4 permits that were continued for 23 years.
That's
aren't we?
correct. And actually, all of the streams, except for, I think, one, are in the area under one of those permits.
So it's not like there's a new permit issued
That's
every year. It's just the conditions for the permit continuing may change.
Yes.
But it's really only 4 permits that ever existed, wasn't it?
Yes, that's correct.
Okay, thank you.
And we would argue that the temporary nature of the permits affords members of the public like Sierra Club even additional sunshine opportunities
thank you,
to address
counsel.
them. Thank you.
Good morning, Your Honors. Trisha Akagi appearing on behalf of A&B and EMI. I'm just going to jump right into the discussion that the court has been having with Deputy Attorney General Goldman. I'm going to start with Judge Leonard's question about the constitutional property interest. So Article 11, Section 9 discusses, does not set forth the constitutional property interest. It does declare that there is a right to a clean and healthful environment, but Article 11 makes clear that that right needs to be defined by a statute or a regulation. And so here, while in Maui Electric, there was a specific statute that defined a right to a clean and healthful environment, that is not present here. One of the statutes that Sierra Club relies upon, I will say that we set all of this forth in our briefing, but just for an example, HRS Section 171-55, which is the statutory authority for the court to issue these one-year revocable permits that are the subject of this case. So 171-55 says in relevant part that the BLNR may issue permits for the temporary occupancy of state lands or an interest therein on a month-to-month basis by direct negotiation without public auction under conditions and rent which will serve the best interest of the state. There is nothing in that statute that requires any explicit consideration regarding environmental factors. There is no direct.
Don't the best interest of the state include interests that impact environmental factors?
They could, but they don't always. So HRS 171-55, as I mentioned, is the statutory authority for the board to issue all types of revocable permits. So it could be a parking space at the airport, which I would argue there's really no environmental considerations related to issuing a parking
Okay,
space at
but
the
this
airport.
isn't exactly a parking space at the airport, is it?
Exactly. But I think if we compare HRS 171-55 to the statute that was at issue in Maui Electric, you will see the difference between the two statutes. So in Maui Electric, the statute that was at issue was HRS section 269-6B. And this was about the general powers and duties of the Public Utilities Commission, or the PUC. It says, in making determinations of the reasonableness of the costs pertaining to electric or gas utility system capital improvements and operations, the Commission shall explicitly consider quantitatively or qualitatively the effect of the state's reliance on fossil fuels on, among other things, greenhouse gas emissions. So in that statute, there is an explicit directive that the agency must consider these environmental factors. If we look at HRS section 171-55, there is no explicit direction. So I agree that there is a possibility that the best interests of the state could include environmental considerations. It doesn't always. And looking at that statute, we cannot identify what is the environmental quality right that is being set forth there, because there's no guidance in the statute.
Isn't the availability of water an issue of environmental quality?
It is.
And that's what the proceeding before the board was considering, wasn't it?
It was considering that. But does the statute, HRS section 171-55, mandate or define specific environmental considerations that must be taken into account when the board makes the decisions? And it doesn't. So Chief Justice Rechtenwald's dissent in the Maui Electric case, I think, is very instructive on this. In his dissent, he cautioned that by expanding the right that's defined, or the interest that's defined under Article 11, Section 9, beyond the plain language of these statutes, that you are beginning to do exactly what the constitutional conventioners did not want to happen, is you are creating a body of case law defining the content of this right by judicial decree and not by the legislature. In the Maui Electric case, they discuss a committee report from the 1978 Constitutional Convention in which they specifically said, developing a body of case law, defining the content of the right could involve confusion and inconsistencies. On the other hand, legislatures, county councils, and administrative agencies can adopt, modify, or repeal environmental laws or regulation laws in light of the latest scientific evidence and federal requirements and opportunities. Thus, the right can be reshaped and redefined through statute, ordinance, and administrative rulemaking.
So, Ms. Akagi, are you arguing that because of the way Section 171-55 is worded, that there is never going to be a constitutionally protected property right at issue anytime the board considers continuation of a temporary revocable permit?
No. So what I'm saying is that HRS section 171-55 does not create or define a constitutional property interest. That does not mean.
If that's the case, then why would there ever be a requirement to have a contested case hearing?
So for example, there could be, the court has said that the protection of Native Hawaiian traditional and customary practices is a right that's actually created by Article 12, Section 7 of the Constitution. So if you had a party that wanted a contested case hearing to challenge or protect their right to practice Native Hawaiian traditional and customary practices, you could have a contested case hearing under those circumstances. So there are other means or other constitutional interests that people could have that would warrant a contested case hearing on revocable permits. It's just that Sierra Club has not identified one, and that HRS section 171-55 alone does not create one.
Thank
I'd
you.
like to turn to the second prong that the court was also discussing with Deputy Attorney General Goldman. And I'm going to start with Judge Leonard's question about, how should we think about the revocable permits? The fact that they've been continued for a number of years, does that affect the way that we think about them? And I would say no. The Hawaii Supreme Court recently issued the Carmichael decision, in which case they made clear that the temporary nature of the revocable permits distinguish the RPs from long-term leases. That's both.
Yeah, but I understand what you're arguing, but here we're going on decades. Is it temporary when it goes on over and over again and the state can't tell me when there's going to be a long-term solution? That's troublesome to the court, at least this judge. How do you see this issue being resolved? Because the temporariness of it seems to be fleeting because it's issued every year for decades.
I understand that it's been issued, or the same revocable permits have been continued for a number of years. But the important distinguishing factors that the Supreme Court had noticed were both the month-to-month nature of the revocable permit, but also the mandatory annual review. So that, to me, distinguishes a long-term lease. If you have, let's say, a 30-year lease, then parties are given an opportunity at the beginning of the 30 years to comment on how this lease would affect their interest. Here, when the RPs are subject to mandatory annual review, every single year, the parties are given an opportunity to again present new evidence, present new argument, and explain how the RPs, if at all, affect their interests, or what additional protections needed to be in place to protect their interests.
So at the end of the review, shouldn't there be findings? So at the end of the November 20, where counsel before you characterized it as a fact-finding hearing, there are no findings.
There were no findings made at this time. So the board's decision that was made, that's at issue here, was made prior to the Hawaii Supreme Court's decision in Carmichael, which provided the guidance that to authorize revocable permits under HRS section 171-55, specific findings needed to be made that the continuation of the permits serve the best interests of the state. So yes, I will agree that there were no specific findings, but that is irrelevant to the question before us of whether the Sierra Club was entitled to a contested case hearing on the revocable permits.
Is a contested case hearing the only vehicle that produces findings? Or can the board, or has the board produced findings without a contested case hearing?
In recent years, the board has produced findings without a contested case hearing. The staff submittals are very lengthy, and the staff makes recommendations as to findings that the board should make, and the board can adjust those or amend those and then make a final decision when it makes its decision what findings it is actually making.
But one of Sierra Club's concerns here appears to be the inability to cross-examine the board, the board's witnesses, the staff, the staff opinions, if you will. And I'll let you answer the question without counting it against you. But so the question is that a meaningful evidentiary hearing when they're not allowed to really challenge the evidence?
I don't believe that I've seen any authority that says that cross-examination is foundational to due process. And in fact, the Hawaii Supreme Court has said that due process is flexible and depends on the circumstances. Here, it's not just the opportunity that the Sierra Club had at the November 2020 BLNR meeting to provide evidence or argument, but that was just months prior to that. The Sierra Club had completed a full trial on the continuation of these exact same revocable permits and had an opportunity to cross-examine witnesses, present evidence, present argument about how its interests were affected by the continuation of these RPs.
Thank you,
Thank
Counsel.
you.
Good morning
Good
again.
morning. May it please the court. Mariana Lowy Gersmar, Deputy Corporation Counsel for the County of Maui. The County of Maui has a very limited appeal in this matter, so it's just the February 2nd, 2022 order imposing attorney's fees for the county. We believe that the private attorney general rule, in particular the third prong, was not complied, and therefore the decision would not benefit large number of people over long periods of time specifically. And because this was not satisfied, we don't believe the county should pay for the attorney's fees, Sierra Club's attorney's fees. Even if attorney's fees were awarded to Sierra Club, we believe that 5% was excessive. The county only joined a couple motions and then just wanted to intervene basically because we get water for upcountry Maui for domestic users and the Cool Agricultural Park. And that is a very limited interest that the county has in this appeal. So we're asking this court that even if there are attorney's fees imposed to the county, will be reduced to the 1% that was the only thing that could be attributed to the county's actions. And this is based on Kelikini versus Yoshioka, basically. And while this case say that the county, the city and County of Honolulu in this case could be imposed the total of the attorney's fees, the city and County of Honolulu in this matter took a leading role, which is not the role that the county has. That's our main argument this time. I do not have anything else to argue, so I'll leave my time for BLNR or AMB and EMI if there's any extra time, unless there's any questions. Thank you.
Thank you very much.
Thank you.
Mr. Frankel.
Aloha, Judge Leonard, Judge Hiroka, Judge Nakasone. The Board of Land and Natural Resources denied the Sierra Club its right to be heard in a meaningful manner. The board authorized A&B and EMI to take all the base flow from a dozen streams without having to face questions from those adversely affected. When all the base flow is taken from East Maui stream, it is drained dry 80% of the time. A month before BLNR's decision, BLNR's Division of Aquatic Resources investigated one of these East Maui streams, Ili Ili Haele. They found Oopu and Opai. The division concluded that this stream had high potential for habitat and it was a high priority for restoration.
So, Mr. Frankel, let's go back to the legal arguments a little bit first, because the main issue I think you're arguing is that you're entitled to the contested case hearing, not for a particular factual outcome. This court can't do findings of fact. I'm pretty sure about that. So you agree that the due process right here is constitutional, not statutory, not
Correct.
pursuant to a rule. And I believe you agree that constitutional due process does not in every case require a contested case hearing. Is that correct?
That is correct.
Okay, so why was the process you were provided in this case inadequate? Because you were given a right to argue, you were given a right to submit evidence. I think you've argued in your briefs that, well, we didn't have to give them everything at the Sunshine hearing because we're entitled to a contested case hearing. But what is faulty about the process you were given, constitutionally faulty about this process?
So let's focus first on cross-examination. There is case law here in Hawaii that emphasizes the importance of cross-examination. That's Mortensen and the Wyola case. I'd also point point out to you Professor Eric Yamamoto's favorite U.S. Supreme Court case, Goldberg versus Kelly. All these cases emphasize the importance of cross-examination. So the Sierra Club was barred from cross-examining, for example, A and B about its use of water as reflected in the recent water quality reports, how the water was actually being used and how much was being wasted. They were barred from asking the Division of Aquatic Resources regarding its recent site visit and its prioritization of East Maui streams.
Mr. Frankel, weren't those questions asked by members of the board?
No, Your Honor, they were not. And to answer your question earlier, there's no transcript in the record, but no, those questions were not asked. And that is part of the frustration the Sierra Club has had for years, decades, is the board has not been asking the hard questions that it needs to of an applicant. The public trust doctrine requires that the board hold an applicant to its burden, and the board has not been doing that. But that's pretty much a different case, the trial case that you'll get to. Other questions that they were not able to ask. Not able to ask Mahi Pono regarding the limits on water use it had recently agreed to in nearby fields. It was not able to ask questions about this new definition of waste. So those are sort of highlight the importance of cross-examining. But let's also confront the issue of the August 2020 trial. There was new information available, dramatically new information. One is the site inspection by the Division of Aquatic Resources and its conclusion. These streams had not previously been investigated. There's really very little data on the streams, and now the board had them, but ignored them. And we couldn't highlight that because there's no opportunity to cross-examine. Another issue is less water was being used than A&B had claimed it needed to use. There was a new quarterly report. Another issue was that they were asking to take more water than they had in previous years, 38% more water. The data that the Sierra Club had assembled showed that most of the water that A&B was taking from streams was wasted. So streams were drained dry and the water was wasted. This is information that we needed to bring to the board's attention and different from what happened at trial.
So Mr. Frankel, and this is sort of the flip side of what I was asking Ms. Goldman. One of the problems I see is that your position is that you get a contested case hearing every time a revocable permit or continuation of the revocable permits is issued. Is that correct? You think you're entitled?
No, I don't think that's accurate. I think we are entitled to, under Flores, we're entitled to one if there's new evidence information that's material. If it's not material, we're not entitled. If there's no new information, we're not entitled. But if there's material new information, then it is required. If you look at In re Gas, Justice McKenna's opinion, she talks about the continuing duty, the public trust duty. So with each year, they have to think about things carefully.
Did the environmental court reach that issue of material new information?
Yes, it did.
Okay.
I think it's, I want to say finding fact 9, in which it lays out all the new information. So yes.
Mr. Frankel, didn't the Sierra Club have the opportunity to present its own submittals to the board?
Sure.
And
sure.
It did, in fact, didn't it?
It did.
Why couldn't the information have been presented in those submittals? And as I recall, you also testified before the board.
Sure.
So couldn't you have raised that information during your testimony?
And I think a lot of it was, but here's the reality. Most of the information that's pertinent comes from Alexander and Baldwin itself, or the Division of Aquatic Resources. Quite frankly, we don't have the funding to have an expert witness go out and examine all the streams and come up with a conclusion, but the state does. Their staff did an investigation. And so we presented information, but we're handcuffed because it's not a contested case. In a contested case, we can summon witnesses and cross-examine them. Alexander and Baldwin has all the data regarding water use and how the water was actually used, and they use some fuzzy math that should be exposed through cross-examination. They'd previously claimed that they had used, I think, 6,500 gallons per day to irrigate the fields for grazing. And that information proved to be inaccurate. So these are the kinds of things, in adversarial process, you can draw out that information. So
Is your position that an environmental impact statement is required prior to issuing any revocable permit?
It was, and we pointed that in our testimony and in our petition, yes.
Okay, so how does anyone ever get a revocable permit in this state if you have to have an EIS for each one?
So first of all, environmental assessment in many cases suffices, which is far less rigorous. And also you can be exempt from many of these cases, whether it's I don't know,
Is
an
there an
airport.
exemption that applies here?
There's no exemption that applies
Okay,
here.
so I'm talking about, and the point I'm really getting at is, it seems that it would be virtually impossible to get a revocable permit every year if they had to go through the EIS or even the EA process following a contested case hearing.
So, first of all, Namoku and the Sierra Club have been pointing out since the year 2001 that an EIS needed to be done. That was the heart of the Carmichael case. And once they do it, there's an administrative rule, I want to say it's 11-200.1-22, I think, or 20, which says once you've done an EIS, you don't have to do a new one every year. So no, I don't think it's a problem. The problem has been that Alexander Baldwin and the state intentionally dragged their feet on doing this EIS for decades. And in this case, they granted them permits to take more water than had been taken before without completion of an EIS. We'd raised that issue. That would have been a part of the contested case hearing had the board granted that original request.
So what happens if we agree with you and say that what happens when the year ends? What happens to the water? What happens to the users?
So, okay, this case is moot. This case is for the permit in 2021. We're done with that. Secondly, the Carmichael case invalidated these very permits. And third, last Friday, the board has issued an entirely new permit. So it's moot, but there's exceptions to the mootness doctrine.
A new permit or continued?
No, it's a dramatically different permit. I think we all agree as to that. Obviously, it's not in the record. But as was alluded to, we have filed an oral request for a written request on this new permit. We may or may not follow through with a written request. So it is important that this court render a decision in this, even though technically everything is moot.
But you did argue that this is capable of repetition. And
no one has raised the mootness issue, but I think the Carmichael case is clearly applicable, and so yeah. I do want to address a couple other things before diving back into everything we've talked about and more. I want to point out that on your website, the summary of this case is incorrect. It refers to West Maui.
Duly noted.
Okay. I also think, for the sake of judicial economy and clarity, the appeal of the court's trial decision on the 2018 and 2019 decisions should be made before this one. There's going to be, I foresee significant problems if this case is resolved first. All three of you are on that panel. I'll leave it at that. I want to acknowledge what Bill and I said earlier. The operative date for this decision is early November 2020. At that time, an EIS had not been completed. At that time, the Water Commission had not required any mitigation measures for the dozen streams. And at that time, the trial court's decision had not been made.
Since we're going into history, I have a question.
Yep.
There's currently a contested case going on for the 30-year water lease application, isn't there?
Boy,
yes or no?
So that's not in the record. It's kind of complicated. Namoku made a request back in 2001. That hearing can sort of happen in fits and starts, but nothing has happened in over a decade.
Has Sierra Club attempted to intervene in that contested case?
There hasn't been an opportunity to do that. I think what's going to happen is when a real lease goes out, there will be an opportunity then, because it'll come up to the board for another decision. If you look at, and this is not in the record here, but what the board did in 2001, it talked about, it didn't vote to grant a lease, but it did put the issue up. And so there's some ambiguity in how the staff submittal is interpreted, but there should be another opportunity to intervene when it comes to the leasing.
Well, Namoku ordered the contested case, didn't it? The Namoku decision required.
This is Judge Hifo's decision you're referring to? I'm not sure. A lot of this stuff is not in this record. And so it's.
Well, my question is, there is a contested case that's supposed to happen for the 30-year lease application.
That's fair.
So why hasn't Sierra Club tried to use that as the vehicle to present its concerns?
So we will. That has been in limbo. Nothing has happened in that matter for about 15 years. I think the last thing that happened was in 2007.
Hasn't a contested case been docketed?
No, nothing's happening. It's not. There's absolutely nothing. But there's cases where NHLC representing Namoku has filed actions to make the board reconvene it, and Judge Nishimura ordered it, and then the board refused to do anything. It's just you don't have all this in your record. It's very complicated, but it has been frustrating because the board has refused to create these opportunities. So I want to address something that was raised earlier about the. I want to get to the second part of the due process analysis. I'll go back to the first later, but you raised an interesting point, both Judge Hiroka and Judge Leonard. So there's actually 3 lines of Supreme Court cases which no one has attempted to reconcile. They're not irreconcilable, but it's kind of interesting to think about. One is, if there's a constitutional right involved, you automatically get a contested case hearing. This is what the court says in Pele Defense Fund, in Bush and Aguiar. And in fact, Judge Leonard, in your Waikamoy decision, that's the exact analysis you went through. Chapter 91 requires, this is the process. The process was already answered by the legislature in adopting Chapter 91. A second case, or an analytical framework, is set in the Iao case. And it says, basically, if a decision involves significant thorough analysis and fact-finding, if the ramifications of the decision could offend the public trust, and if the decision would affect individual rights, then yes, you get a real full-blown contested case hearing. And then, more recently, we've had the renaissance of the 3-factor test. And it doesn't matter to the Sierra Club which of the tests you decide to apply. But we can go through the 3-factor analysis.
I'm sorry, are you saying that if we agree with Sierra Club that it had a constitutionally protected property interest in the matter before the board, we need go no further and we don't have to apply any tests because we should automatically hold that a contested case hearing was required?
So that's what 3 Supreme Court cases hold. Pele Defense Fund versus.
I'm saying under Hawaii law.
Yeah, Pele Defense Fund versus Punajia Thermo, it's a footnote. Under Bush, Bush versus, I think it's Hawaiian Homes Commission, and Aguiar, and they're all cited in our brief. And the Waikamoy decision.
Is Flores no longer good law?
It is. It clearly is. What I'm pointing out to you is there are these, and the Supreme Court has not rejected those prior cases. What I'm trying to point out is there's 3 different analytical approaches which the Supreme Court has not really wrestled with. But we can go through the 3-factor test. We're happy to do that. So the first step is, what's the private interest at stake? And the private interest is the Sierra Club's constitutional rights. And there's actually 7 rights that are raised under, first, it needs to consider the state's best interest pursuant to 171-55. And those best interests include resource protection, which the Waihole Court talks about. Second, it requires full disclosure of environmental impacts pursuant to HRS Chapter 343. Third, it requires full consideration before decision-making of environmental impacts under HRS 205A-4A. Fourth, protection of coastal ecosystems. That's what HRS 205A-2B4A requires. Then there's effective regulation of stream diversions that minimize disruption or degradation of coastal water ecosystems. By the way, this language is far more specific than the language that the Supreme Court relied on in Maui Electric regarding greenhouse gas emissions. Sixth, stewardship and the protection of coastal resources. That's HRS 205A-2C4A. And ensuring that public trust resources are properly managed. So these are all constitutional rights of the Sierra Club that are adversely affected by by authorizing A and B to take all the base flow from a dozen streams. What's the risk of erroneous deprivation? It's high. In fact, we know it was committed. First, the board made a decision without making any legally required findings, which under Carmichael we know is required. Secondly,
Well, didn't Carmichael come out after?
sure, but the law,
So
that
at
was
the
always,
time, wasn't the only requirement for findings and conclusions if there was a contested case?
no. And that's not what the Carmichael court said. Carmichael is not making new law.
Counsel, Carmichael was decided after
Correct.
November of 2020.
Right, but
So
it's,
at the time the board was conducting this hearing, what was the source of a legal requirement for the board to make findings and conclusions?
the literal language of 171-55 in the public trust doctrine. The Supreme Court's articulation of its decision does not mean that that wasn't the law beforehand. That's always been the law, but the board has refused to comply with the law. I mean, this is what we've been arguing consistently, that they've been making decisions without making findings. So, my time is quickly coming to an end. I want to also point out that the board has a substantial interest in conducting a contested case to fulfill its requirement to make findings, to develop a record, and to ensure that A&B fulfills its burden. I want to mention one thing that Ms. Goldman didn't raise, but she's going to in her rebuttal, because they make an extensive argument in their answering brief, not their opening brief, that the Judge Crabtree could not modify the board's decision. 91-14G explicitly allows it. The Supreme Court's decision in Nakamini versus Board of Trustees of ERS, which is 65 Hawaii 251 at page 255, explicitly authorizes that.
Wait, I have
doesn't-
a question. Doesn't 91-14F only,
G.
I know, but I'm talking about, I thought that was they only get to that if there's a trial or evidentiary hearing provided by law, or there's alleged irregularities in the procedure before the agency not shown in the record. I mean, how does he's sitting as an appellate court, isn't he? The environmental court judge?
You could say that. I mean,
Okay, so believe me, I've been told numerous times by the Supreme Court that appellate courts don't make findings of fact. What is the authority on an appeal?
I would cite Leslie versus Board of Appeals. I would cite Nakamini versus Board of Trustees of Employees Retirement System. Again, 65 Hawaii 251, 255. I would refer you to HRS 603-21.9.
What about 604A-2? You cited that.
Yes, Your Honor.
So it says general equity powers is authorized by law. Does that include what the court did? I mean,
Yes.
what guidance is there as to what that entails? As authorized by law, like where are we supposed to look?
So you also have a rule, I can't remember what, I think it's Rule 65 of the Rules of Hawaii Civil Procedure that, no, it's not 65. Anyway, the court is supposed to enter findings when it issues injunctive relief. Whether this is injunctive relief or not is highly ambiguous, but it needs to justify its decision. And that is why these findings, quote findings, were made. And the Sierra Club's due process rights were violated. He is searching for a remedy.
Counsel, let me just ask the judges, do you have any more questions for Mr. Frankel?
Yes, I do.
Okay, we're gonna go with that. Because your time's up.
Yeah.
The environmental court statute does give the court general equitable powers under the law. wasn't the proceeding before the environmental court, in this case, an agency appeal under 91-14?
Yes, Your Honor.
And 91-14 only applies to decisions rendered in contested cases, doesn't it?
No. If you look at Mahuiki, if you look at.
I'm sorry, I'm looking at the language of 91-14A.
I understand. And I'm referring to multiple Hawaii Supreme Court cases which have interpreted the term contested case hearing in two different ways. One is the way you just used it, but there's an alternative way. If you look at Mahuiki, Mortensen, if you look at one of the old Life of the Land cases, if you look E&J Lounge, there are a plethora of cases in which the court has essentially treated a contested case for the purposes of appeal.
E&J Lounge involved the Liquor Commission, and that statute required a contested case hearing, didn't it?
So that was not a constitutionally based hearing, correct? That was a statutorily based hearing.
All right, so 91-14A only applies to final decisions and orders in a contested case. And there's another section in Chapter 91 that requires findings and conclusions in contested cases.
Correct.
And in Chapter 91 appeals, the environmental court, because it's a circuit court, sits as an appellate court.
Correct.
And its job is to review the decision of the agency to determine whether the agency's findings were supported by substantial evidence and whether the conclusions of law were right or wrong. What in Chapter 91 authorizes a circuit court in a 91-14 appeal to make findings?
So I would refer first to 91-14G, but more importantly, I would refer you to several decisions of the Hawaii Supreme Court.
I'm just talking about statutory interpretation.
Well, but these cases interpret the statute. So
what about the statute
So-
gives the circuit court?
So you're relying on 91-14G, is that correct, counsel? The statutory authority, that's your statute.
No, it's also 603-21.9, 604A-2. But I am also very much relying on multiple decisions of the Hawaii Supreme Court. We've cited some of them, but most of this argument that you're addressing was raised in Beal and R's answering brief. We've had no opportunity to answer them, but I can, because it's an answering brief, we don't get a chance. But if you want briefing on that, I'm happy to prepare that for you. But there are multiple Hawaii Supreme Court cases interpreting the term contested case in a way that you're not using, and I understand that, but this has been the law since the Mortensen decision a long time ago. I think that's Justice Nakamura's decision. So you got to go back to that to interpret how you look at the word contested case.
Anything further? Judge Nakasone. Thank you, Mr. Franco.
Thank you.
Hi. I want to start by addressing a question that I believe Judge Leonard had asked of Deputy Attorney Goldman, and that came up in the discussion with Mr. Frankel, talking about, this is a new year. The August 2020 trial had addressed the 2019 and 2020 RPs, and at issue here is the 2021 RPs. Doesn't that mean that there should be another contested case or a contested case hearing, even though there was a trial? So the Flores case is instructive on this, because in Flores, the contested case hearing that Mr. Flores participated in was on the CDUA, but the issue that Mr. Flores sought to have a contested case hearing on was on the consent to the sublease. So it was two different things. So there's no requirement that the participation be regarding the exact same issues. What the Supreme Court said was that Mr. Flores was given a full and fair opportunity to express his views and concerns as to effect that these actions would have on his interest in engaging in traditional Native Hawaiian cultural practices on Mauna Kea. So even though the subject of the BLNR decision was the year following the years that had been an issue in the trial, it was still the exact same content, the revocable permits.
Yeah, but what Mr. Frankel seems to be arguing in part is that there was 38% more water permitted to A and B and other changes that required further examination to
So
protect his client's interests.
there was actually not an increase in the authorization to divert water. In the first year of the trial, the BLNR had set no cap on the amount of water that could be diverted pursuant to the RPs. In the second year, the 2020 RP, the board had set a 45 million gallon per day cap. That same 45 million gallon per day cap was the cap that was set by the BLNR for the 2021 RP. So there was no increase in the amount of water that the board had authorized to be diverted pursuant to the RPs between what was argued in the trial and what was before the BLNR. The other issue is that even if there is new evidence, that does not entitle the Sierra Club to a contested case hearing. So in Flores, the Hawaii Supreme Court had said that Mr. Flores already had an opportunity to express his concerns and how this action would affect his interest. So even though the terms and conditions of the RPs may change, the action and how it affects the Sierra Club is not materially different based on this information that the Sierra Club says is new. So for example,
Well, before you go on, so are you saying that a contested case hearing, even if we thought a contested case hearing might be required in some instances, we could narrowly look at this case and say it wasn't required here in large part because of the August 2020 trial?
yes, that's correct. I think it's very possible to limit the decision to the unique circumstances of this case.
So it would only apply, it would have very little precedential value. It would only apply to the 2021 revocable permit.
I think that the court could make a decision that would just be limited to that, given the recency of the August 2020 trial and the similarity in the information that was available. And so one of the things that the Sierra Club had pointed to was a recommendation from the Division of Aquatic Resources regarding the search and restoration priority of these 13 streams that were not the subject of prior IFS petitions before the Water Commission. But in the trial, the Sierra Club cited to the opinion of the Division of Aquatic Resources that one of those streams had a large amount of potential habitat. The Sierra Club argued extensively at the trial that all of these 13 streams needed some level of protection by the BLNR. So the argument that the Sierra Club is advancing by saying, well, the Division of Aquatic Resources, rather than saying one stream is high priority, there are other streams, is simply to say that the board needed to take action to protect these 13 streams, which was thoroughly argued in the August 2020 trial. Another issue is the water usage in the third quarter report that was filed by A&B and EMI with BLNR. Again, this just goes to the amount of water that was used, but how does it affect the Sierra Club's interests? As I had mentioned, the cap remained the same. So the amount of water that was authorized to be diverted, Sierra Club had an opportunity to explain how a 45 NGD cap would affect its interest in the trial. So even if there was additional information, Sierra Club already had an opportunity to address the effect of that on its interests. Thus, by its request for a contested case hearing on the continuation of the RPs for 2021, Sierra Club was seeking to express the same concerns it had raised and addressed in the August 2020 trial. In addition, it was seeking to vindicate the same interests as in the August 2020 trial. And we know this because the declarations that Sierra Club attached to its written petition for a contested case hearing to support the interests of its members are the exact same declarations that the Sierra Club used in the August 2020 trial proceedings. So the interest that Sierra Club was seeking to vindicate in both the trial and before the board regarding the 2021 RPs was the same. So this is very analogous to Flores because Sierra Club was afforded a full and fair opportunity to express its views and concerns as to the effect of the continuation of the RPs, and the contested case hearing sought by Sierra Club was simply to express the same concerns and vindicate the same interests as in the August 2020 trial. I think my time is going to run up very quickly, but I just wanted to briefly mention, oh, it's over. Thank you.
Thank you very much. Let me ask, any questions? Okay, thank you.
Thank you, Your Honors. May I ask how much time I have with the?
Go ahead.
There's a total of 6 minutes and 50 seconds left, including the leftover time from.
Okay, thank you, Your Honors. I will try and be brief here. There's a bunch of things to address. I'd like to address the contention that the 2021 RPs authorized diversion of all of the base flow. That is patently false. That is based on a technical error that was made in an answer to the statement of the case before Judge Crabtree. It's actually, there's an aggregate cap, as Ms. Akagi mentioned. There's also interim in-stream flow standards, which mandate minimum amounts of water that have to stay in the stream. So you can never go above a certain amount if it's going to interfere with the IIFS. Additionally, all the RPs include a condition that they must be diverting water for reasonable and beneficial use, not waste. So certainly all of the base flow was not authorized. Regarding the DAR prioritization study, which is docket, you can see it in docket 32 at PDF page 5. Respectfully, Sierra Club misconstrues the study. It evaluated only 12 of the over 35 affected streams, and its conclusions clearly state they are relative prioritization between the 12. It did not identify overall restoration priorities for the watershed. Additionally, board findings before Carmichael, our position is that when the board votes to accept or to modify in some way the staff recommendation, in doing so, the board is adopting the information and statements made in the submittal as its own findings. And here the submittal was quite lengthy. Additionally, there is no transcript in the record, but there is, I believe you are all provided with an audio tape. That is our full record of the hearing. The minutes are summary minutes. Let's see, docket 53.
The recording is available on the board's website, isn't it?
It is available on the board's website. I know that before the circuit court, we also submitted an audio CD, but it may have been lost in the shuffle coming up to you. We'd be happy to provide one if that's helpful. Also, the 91-14 question regarding whether that statute can cover the review of a contested case hearing, denial. That's discussed in the Kalakini v. Thielen case. I believe that might be the most recent case that discusses it, and it cites some authority as well. 124 Hawaii 1. Let's see, it's page 14 of that opinion. Additionally, sorry. Okay, cross-examination. So I'd point to a few different cases, but first I'll mention constitutional due process does not provide an absolute right to cross-examination of information or agency experts who make recommendations simply because a party disagrees with them. Courts have correctly recognized that cross-examining agency scientists rarely produces useful information. And where identifiable rights go unearthed, core due process rights only guarantee notice and a fair chance to dispute the anticipated decision. Some of the cases you might look to for the cross-examination point are the Medeiros case, that's 8 Hawaii App 183. Sandy Beach talks about it, pardon me, 70 Hawaii 361. Sierra Association for Environmental versus Federal Energy Regulatory Commission discusses it, 744 F.2D661. It's also discussed in the Butre case from the United States Supreme Court and the In re application of Maui case, the Miko case that we often cite to 141 Hawaii 249. So here,
Ms.
Sierra,
Goldman,
yes,
I have a background question
yes.
that I wanted to make sure I ask you. What is the status of the 30-year long-term lease application before the board?
Well, it's difficult to say, Your Honor, but as I mentioned earlier, the environmental review is complete and was not challenged. That's a huge burden or a huge step, a hurdle towards that process that's been done. I believe there's still sort of negotiations going on in terms of the leasing, and there's also, you know, a need to value the land and all of those sorts of things.
So in the Maui Tomorrow case, it appears that the board granted the request by Maui Tomorrow and Namoku for a contested case. Has one been docketed?
Not that I'm aware of.
Why not?
However, the Namoku case, pardon me.
Why not?
So the Namoku case, it was essentially about the lack of HRS 343 compliance, which has since been completed. My understanding is that that case has been informally stayed, and as Your Honors correctly observed, Sierra Club has not moved to intervene. It's been up and down between the Supreme Court and the appellate courts a few times over the
Has
years.
Sierra Club had an opportunity to intervene in the contested case that BLNR agreed to conduct?
I believe so. They could have filed some sort of intervention at any time before the circuit court, but have not.
Or
I'd also
before the board? Is there a mechanism for Sierra Club to move the board to intervene in the contested case?
Yes. Generally, my understanding or my experience is that that happens once the contested case is docketed and starts moving forward, then parties can intervene.
And it hasn't been docketed.
No, and it's unclear whether it will, because again, it was about the lack of 343 compliance, which has since been addressed and resolved. However, that's not a case that I am intimately familiar with, so
I understand.
I don't want to misstate anything further.
Thank you.
My time is up.
So I do want to give you a chance to respond to Mr. Frankel's assertion that you would be arguing about the circuit court's ability to make findings. I think I asked you so many questions to begin with. I'd like to give you a chance to answer that. Whether the circuit court should have been making findings on a Chapter 91 appeal of the nature made in this case.
Yes, no, Your Honor. It's very clear here that the circuit court was sitting in an appellate capacity here. The circuit court 91-14 allows for reverse, affirm, or modify, but we would suggest that modify really only would be appropriate when a full evidentiary record has been developed. Here, by ruling that Sierra Club was entitled to a contested case proceeding under Flores, that means the court was ruling that the record before the board was insufficient without Sierra Club's interest being more formally found. So sitting in its appellate capacity, it was inappropriate for the court to then determine that Sierra Club's contention about how much water should be diverted was the appropriate amount. I also just wanted to mention the nature of this interest is a collectively held one here. This clean and healthful environment, hiking, swimming, all of those things. And there's certainly an argument to be made that a public sunshine meeting is the more appropriate forum.
Thank you, counsel.
Thank you.
Before you go, let me just check. Judge Hiroka?
I do have a question. Thank you, Judge Leonard. Can you respond to Mr. Frankel's assertions that the term contested case under Section 91-14A also includes proceedings that aren't technically contested cases as defined by Chapter 91?
Yes, Your Honor. That would be the Kalakini v. Thielen case, but there's also several cases in this jurisdiction that seem to recognize that in some situations, a sunshine hearing can give all of the process that is due. And so the sunshine hearing has been considered to have been a contested case hearing. That's in the Medieros case, for example, Hawaii App 183.
So are you arguing that we should construe the sunshine hearing in this case to have been a contested case hearing? I mean, either you are or you're not.
I'm not sure I would go so far as to say that because I'm not sure that's required in order for the court to have jurisdiction under 9114 under the case law. However, it does seem that that's the direction the case law has been going.
Judge Nakasone, do you have any more questions? Judge Hiroka?
Thank you.
Thank you, counsel.
Thank you very much, Your Honors.
We will take this matter under advisement.
Iku Iruna, all rise. Ua ho'oku'u ia mai nei ka'aha. The court is now adjourned.
Recording stopped.